The event today will be broken down into 3 sections. The first will be discussing current and potential law and court action in the federal arena. The second section will be discussing current and potential law and court action on the East Coast, where our firm practices, and as well on the West Coast in the states where our firm practices. In the third section, when we're discussing West Coast matters, we'll be discussing 2 states and not the entire West Coast. If you have any other questions, our West Coast counsel can help you with that. The East Coast states were pretty much the entire Mid-Atlantic, where I think most people have offices who are here today. Finally, although we'll be discussing federal and state legislation in the federal courts, it's not my intention to engage in political discussions here today. All the opinions and positions stated in the slides are those of members of government that I'll be quoting or paraphrasing, and do not reflect the opinions of our firm, our political views, opinions, or any other matter that we're discussing today. I thought it'd be helpful to provide that disclaimer, and my partner thought it'd be a good idea too. Finally, this is serious material, but we don't take it seriously, as you can see from everything I just said. I've used this slide before in other presentations, and I think I really gave it short shrift and didn't spend a lot of time on it, and wanted to spend some time today. You'll see the 9 slides or so that I have on the federal action are really where we're going to focus today. And the state actions aren't as important, although they do matter. And if we don't get to all of those, the slides kind of speak for themselves. And if you have any questions after the fact, if we don't get to everything, just email me, email anyone in our firm, and I'm sure we can get questions answered for you. So on the 15th of May, the House passed the Health Economic Recovery Omnibus Emergency Solutions Act, or HEROS. And I think I said last time, they must have a special team of people in the government who spend their time coming up with these acronyms. We'll be mentioning a few of them as we go. House lawmakers approved the Democratic proposal to provide $3 trillion in corona relief that would include a new way of funding for state and local governments, workers, and their families. This would extend the Emergency Family Leave Act till 2021, and another round of direct cash payments for Americans, including expansion of the IRS program, where folks would receive up to $6,000 in payments, extended unemployment benefits for $600 a week to 2021, and add hazard pay for frontline workers. This is as well including nearly $1 trillion to state and local governments, including $500 billion in flexible state aid, and $357 billion to local governments and counties. The reaction to this, as you might imagine, with a government with a president and Senate Republicans and the House Democrats, was not favorable. As you can see from the bottom, the Senate Majority Leader and the White House reaction were not favorable. The Senate Majority Leader said that the bill was caked with seasonal catalog of left-wing oddities and not very serious. The president signaled that if this came to him, he would be vetoing it, but it never showed up. As a matter of fact, despite, and sure everyone saw this in the news, despite the Republicans' attempt to come up with their own bill, the HEALS Act, and I'm not going to go through that acronym. So this is what I basically went over in the last few events that we did. And what you'll see is a little bit more detail on the next slides. So the HEROS Act is a combination of small acts that were put together by various leaders in the House. And what concerns us are the 18 pages of the 1,800 pages of this act that deal with consumer collections and, collections across the board. So the part that concerns us was brought to us by Representative Maxine Waters, Democrat from California, and in her opening statement at the hearings on the act stated that the act provides critical relief and protection for renters, homeowners, people experiencing homelessness, consumers, students, small businesses, minority-owned businesses, non-for-profits, state, territorial, tribal, and local governments. I have to say, if I didn't read the bill, I'd say that sounded pretty good. And I think for a lot of people, it might very well be. But when we dive into the HEROS Act and take a look at how it would affect the credit union industry, what we find is this. The legislation would place restrictions on the ability to collect debt, to service accounts, especially because it would place a temporary moratorium on debt collection. What that basically means is, and we'll talk a little bit more, but what this does is it puts a restriction on all consumer collections for the term of the emergency that's defined by the president, plus 4 months, 120 days. So what that basically means is that if all houses and the entire government changes hands on the 20th of January, I think that's right, what you should look at is some sort of HEROS Act coming down the pike, because this was pushed pretty hard and never got anywhere because of current political situation. So what would end up happening is you'd see a bill similar to this, and if it were the case, you would have the president decide when this economic tragedy, when this economic issue, when this problem would be over. And then what would happen is another 120 days would pass before consumer collections would be put back into effect. Well, so you think about this, well, I don't get to do my job. Lawyers and debt collectors are out of work. Problem with that is the HEROS Act broadens the emergency restrictions and makes credit unions, debt collectors, and banks debt collectors of under the FDCPA. So what we see is that anyone who is the originator of a debt is now subject to the FDCPA and the HEROS Act, which means not only can lawyers and debt collectors collect your money, but you can't collect your money. So this becomes fairly problematic because you end up with a bill passed where the president decides when you can start collecting again, and then 4 months have to pass until then. I highlighted a few sections here, and you'll see violation of these emergency restrictions would result in 10 times normal FDCPA fines. So many of you may not be aware of FDCPA fines, but those of us in the debt collection business are. And typically statutory fines are in the neighborhood of $1,000. We can extrapolate out a little bit and talk about when it's class action suits, but just assume that it's $1,000 per violation. In this case, any violation on the part of a credit union, on the part of a debt collector, to do anything to collect debt, whether it be phone calls, letters, whatever you do internally, would be a fine of $10,000. And depending on the event, potentially a per event basis. And again, we get in the weeds on that, but just know that's where that ends up. These restrictions, again, come into play during the covered period, and that's 120 days after the pandemic ends, or when president decides the pandemic ends. And there's always a chance that this could become permanent. And by that, I mean the FDCPA could be changed permanently to include originators of debt or some other language. There's certainly been attempts to do that, and they haven't gone anywhere in the last several years because of the split in Congress. Excuse me. The restrictions, again, as I said, have historically been applied to third-party collectors, but now this would be everyone: banks, credit unions, finance companies, any originator of debt, which this would effectively bar you from collecting debt that you have. And again, it's even sending that 10-day reminder notice. Anything that you do would be barred under this. And what we've seen is that this would probably lead to higher prices and less access to credit, because I'm assuming on the lending side, lenders will want to lend, but on the credit side, you'll have folks saying the more we lend, the more we're subject to people paying if they feel like it. And most people do. I mean, if you look at your percentage of bad debt, it's not 20 or 30%. Most people pay their loans, but just assume that the 1 or 2% or whatever the number is going to be write-off as opposed to collection. With a change in the administration and both houses of Congress, expect some version of this to come down the pike, because it was something that was in every bill, I'll put it that way, every bill that came out of the House for the pandemic or during the pandemic included some version of this, 18 pages from the House Banking Committee, and it was taken out the first time when the bill passed and wasn't considered this time. There was also a Senate bill that looked an awful lot like this, proposed by the Senate Democrats, which never received a hearing or a vote in the Senate because it was Republican controlled. So I want to talk a little bit about credit reporting in the CFPB, because this has also been an issue of the last few months. thanks to the CARES Act. And I'm not going to go into that acronym either. We should all know it by now. It came to us in April, and we've been hearing all about it since. So not to spend too much time on any particular slide, but what I want to do is just basically go over the issues that have sort of been going on between Congress and the current CFPB. And we'll talk a little bit more about what the CFPB might look like in some time from now. So when the CARES Act was passed, changes were made to how credit reporting was done, or basically how you as original creditors have to report to the credit reporting bureaus. So if you look at this, and I'll go through the bullets, if an accommodation is made to modify terms, the debt must be reported as current or the last status reported prior to the accommodation. We actually went through this slide in one of the webinars our firm did. We're doing them monthly now. And some of you may have heard this before, but I'll just go through it again. Accommodations means an agreement to defer one or more payments during the pandemic. Accommodations must be in writing. And this will be in place, again, through from January 31, 20 through 120 days after the emergency is over. Expect the CARES Act amendments potentially continue with a new administration and post-pandemic. I think the more I hear about what's going on with the election, I think it's fair to say that you'll see these as permanent changes. So let's talk a second about these bullets that I have here. So what the attempt here was that if folks were in trouble, if folks were in need and they needed to make an accommodation, and of course, every client I deal with, and our firm deals with a lot of credit unions, we're seeing everyone willing to make accommodations for their members. And again, credit unions don't have customers, they have members, and they treat them that way. So this is a real issue for me or for our credit union clients. What's changed here is that if you're making that accommodation, what you have to remember is it has to be in writing. And once you make that accommodation, the debt has to be reported as current. So even though this may have been 60, 90, 120 days old, and you've now made an accommodation or sent to a law firm for collections, you're now changing how you report to the credit bureaus because of the pandemic and because of this change in the CARES Act, which basically is a change to FCRA. So just bear it in mind, if you weren't at any of our webinars and heard the full version of this, feel free to reach out to us and we can get you more information, or you can find the webinar that discusses this on our website or YouTube or our YouTube channel. So in response to the action by Congress, you saw the CFPB release a policy statement regarding the CARES Act, FCRA, and said, well, we understand, and let me go through the bullets, recognize the operational disruption may preclude furnishers from responding in 30 or 45 days as required under the CARES Act. CFPB pledges to consider individual circumstances if there are good faith efforts to do the things that we just talked about. Mentioned that dispute investigations may take longer and reminds that disputes need to not be investigated if they're terminally frivolous or irrelevant, and their policy statement is non-binding and exempt from notice and comments required under the Administrative Procedures Act. So the CFPB's response to the CARES Act and these new rules were, well, we understand that let's say credit union has to respond within 30 days or 45 days to a request to change a credit bureau report or to change that report based on an accommodation. The CFPB's answer to that was, well, we understand that you're dealing with the pandemic too, and you may not be working fully as well. And we're not going to be such sticklers as it's now 30 days or it's now 45 days, so change it or else, or we'll fine you, or whatever the answer to that would be. Their answer was, if it's a good faith effort to investigate a dispute, deal with the dispute, make the changes, and comply with the statutes, then they're okay with that, and they're not going to push very hard. As you might imagine, this was not received well in the House because, as far as they were concerned, these rules are the rules, and they want to make sure that if the rule says 30 days, it's 30 days, again, to protect consumers. So let's talk a little bit about the CFPB and the action between the CFPB and states attorneys general. So the CFPB has pretty much taken a laxed view on enforcement during this administration. And because of that, they've talked about what they will and won't do with regard to FCRA violations. And I'll go through the bullets here and then we'll talk a little bit more. So in April, 20 attorneys general sent a letter to the CFPB saying, you need to enforce the law. And they will continue to enforce federal laws if the CFPB won't. The states, and again, these mostly came from blue states. I'm not going to go through the states, but you can look it up. States will monitor furnishers to ensure proper credit reporting and timely investigation of all disputes, and they will not hesitate to hold credit reporting agencies accountable if they fail to meet the obligation. So in response to the position taken by the CFPB and the House being unhappy with that response, you saw the attorneys general of 20 states send letters saying, well, if you won't enforce the law, we'll enforce the law. And the position taken by the CFPB is the states are authorized to bring actions, and this was what they said. We understand the states are authorized to bring actions for violations of FCRA. Federal preemptions address conflicting laws in private enforcement. Federal law exempts Massachusetts and California statutes from preemption. So what this basically means is the CFPB said, well, we understand you're going to take action. We get it. We know that there are things that you can do to enforce the law. But if you start to enforce the law in a way where we think it's infringing on our rights to enforce the law, they didn't say they'd put a stop to it, but they certainly didn't say they were going to be happy about it. So you can see from this where the two positions are going. A very strong view from the state's attorneys general and the House on how they expect you as original creditors to deal with these issues, in this case, FCRA, and the president and the CFPB and the current director of the CFPB is a appointee of this president. What you'll see is that one will say, let's make some accommodations, and one will say, the law is the law, let's enforce it. What I found interesting about this was, and I won't go too deep into this, but what I found interesting about this is that when people are dealing with a pandemic and they have financial issues and have to deal with those financial issues, accommodations need to be made for the people who are dealing with these issues. When you as a credit union are also dealing with the same issues because people work at the credit union, the position taken by these attorneys general is, well, everyone else is dealing with a pandemic. We don't care if you are too. You're going to enforce the law the way you choose to enforce the law. The CFPB's position was what I just said, which is everyone's dealing with this. We can't enforce this to the letter. It's not possible. So the tension grows, and I don't know that we'll see a different answer from this current CFPB. Although if there's a change in administration come January, then I think you'll see a change in the CFPB, and we'll talk a little bit about that in a minute. So let's talk a little bit about where we see the CFPB heading in 2021. By the way, when Don introduced me and said the event was changes under a new administration, I actually wrote this as potential new administration because I didn't want to suggest that there'll be a new administration. I don't know. If I knew, I'd be in Vegas placing a big bet. So I just wanted to say for us, we're talking about the things that potentially could happen. We know what's going on now. That's easy. What we want to talk about is some changes that we may see. So there was a recent case before the Supreme Court ruling on the viability of the CFPB. You may have seen it in the news. Once the Supreme Court ruled, you may have seen people marching and holding up signs, and you may have seen Senator Warren out in front of those people with the signs saying, CFPB is here to stay. What again, you saw at the CFPB was a Republican attempt to dismantle the CFPB that is a creation of the Obama administration, and the Democrats trying to hold tight to the CFPB because they feel like a Consumer Financial Protection Board is a good idea. Again, acronyms are great in the government. I'm not really sure they all mean what they're supposed to mean, but they are what they are. So the Supreme Court the Supreme Court heard this case on the CFPB's structure, basically. It has, and the way it's written is it has a single director and removable only for cause, which violates the Article 2 of the Constitution. Actually, they considered whether the CFPB structure, a single director, removable only for cause, violates Article 2 of the Constitution. Right now, anyone who's a director of any federal agency can be removed by the President of the United States, who appoints them. So what the CFPB did was, what the Supreme Court did in this case was rule that the authority that the CFPB has stays in place, which was not what the Republicans who are bringing this forward hoped for. So the CFPB emerged from this case, from this ruling, that they can continue to regulate payday lending, debt collection, mortgages, and other pocketbook issues. CFPB leadership is now somewhat more subject to the winds of politics, which is not, again, what Congress, and when I say Congress, I really mean the Republicans, had in mind, or what the current White House had in mind when it attempted to dismantle the CFPB. The Republicans were trying to get rid of the CFPB, not make a determination as to whether or not the director could be removed for cause or not. As the ruling came down, the CFPB stays in place, but now the director can be removed by the president at any time, not just for cause. So I'd say it was kind of a lose-lose for the Republicans on this, as the CFPB stayed in place. And now a president can remove the director for any reason that he wants. So to the next bullet, a President Biden, and I wrote here a President Biden in the event that he's elected, vows to immediately replace the current acting director of the CFPB. He also vowed that we should expect active enforcement under a new CFPB director. As anyone can see that, or anyone who filed the CFPB in the, almost 12 years or so they've been in place, a little bit less, but anyway, you saw very active enforcement during the Obama administration, and a quiet CFPB during the Trump administration. I think you'd expect under a Biden administration enforcement very similar to what we saw under the Obama administration. A lot of people say, this doesn't really apply directly to me or really to me because we're not subject to a lot of these rules. And the answer is whatever happens to the larger credit unions and banks who are subject to CFPB, you can rest assured will trickle down to you at some point. When we saw the ruling, or I should say the consent order with Navy Federal Credit Union, which our firm analyzed and gave our clients information on, you saw a lot of clients saying, well, I understand that only applied to them. What changes do I need to make now because of what happened to Navy Federal Credit Union? So bear in mind, it may not apply to you, but it will affect you. So let's talk about bankruptcy and bankruptcy changes post-2020. So bankruptcy has been a hot issue for Senator Warren and for the Senate. She specifically has sponsored bills and worked very hard to make changes to bankruptcy and reform bankruptcy. There was a Reform Act that I know she was not very pleased with because it didn't go as far as she had hoped for. I want to go through what she has sought, because if there is a change in both houses of Congress and the presidency, you should see a bankruptcy reform act that will look something like this. So let's go through what she's been talking about. And again, these are things that she's laid out, and I just want to talk about it a little briefly. So basically, the first thing is a streamlined process, disclosure assets and debt to the court, saves the arduous paperwork and often costly legal fees associated with the current system. Then, according to her plan, filers would choose from a menu of options for addressing their debts. In one option, a filer would surrender all of their property with exceptions, to their creditors. In exchange, walk away free and clear their debts. Alternatively, there would be an option for declaring bankruptcy on some debts, home mortgage, for example, and simply committing to remain current on your other payments. Not too dissimilar from what we see now, although it does cut down on, again, the paperwork, and it does cut down on the exemptions, but also cuts down on what you're going to have to give back. So it's a change there. Last, the debtor would have the option of filing a proposed payment plan to discharge debt without surrendering assets, which is the radical change, and then petition the court to accept that plan, halting collections to the extent needed to execute it. So basically, all collection activity stops, which it does now in bankruptcy as well. But even on matters where potentially you could lift a stay. So in this plan, there are no lift stays. All that you would see is everything stops until a plan is accepted or approved. Student loans, which are not dischargeable in bankruptcy currently, would be potentially dischargeable under a plan that would any bill sponsored by Elizabeth Warren would have student loans dischargeable in bankruptcy. She has said it, and President Biden has said that he would support such a thing. She would allow people who opt out of payment plans to spend a reasonable amount on toys and books and basically recreational activities. So again, as I spoke a few minutes ago, the exemptions would change, and how you spend money when you're in bankruptcy would change. Bankruptcy filers would be allowed to hold on to their car. Perhaps they need them to go to work, and pay their auto lender a cash equivalent of the current value, rolling back the 2005 change that made them liable for the full amount. So if you're in the car loan business, so I just talked about if you're in the student loan business, you'll start to see discharge in student loans in bankruptcy. In this case, what you'll see is if someone financed a car for $20,000 and still owes you $16,000, if they file for bankruptcy and the value of that car is now $8,000, they owe you $8,000 if they want to keep the car, not the full amount. And obviously, there's no deficiencies or anything in this case because it just gets discharged. Last by no means, Senator Warren wants to create a standardized way to modify mortgages through the bankruptcy process, something that's not allowed under the law. So what you would see under bankruptcy in this case is, again, potentially a cram down on value. So if someone owes you $1 million on a house and their house is worth $600,000, even if they agree to keep the home and even if they agree to keep paying on the home, there would be a modification so that the amount they now owed you wouldn't be the amount they borrowed from you, but now based on the value of the home. So you would see some radical changes to the bankruptcy laws in the event there were changes in both houses of Congress and the presidency. I don't know if all of this would pass, but this is something that Senator Warren has been pushing for a very long time. It hasn't passed because of how the current Congress is constituted. But were that to change, you'd see a lot of this come to pass. So if you're in the loan business, as I mentioned, mortgage, cars, or student loans, and I don't know credit unions who aren't, this could be a significant change to the bankruptcy law. So last, I want to deal with the one acrimonious part of this, and I don't have a lot of time left. So as I said, I wanted to get through the federal section first because I don't know that the states are something we need to talk about specifically, but let's see if we have a minute or two. So as everyone knows, because it's been everywhere, Ruth Bader Ginsburg passed away on the 18th of this year, creating a vacancy in the Supreme Court, and the possibility of a nomination weeks before the presidential election. I don't think it's a possibility anymore. When I wrote this, it seemed like it was. Just some facts that I thought were interesting that you may too when you're discussing these kind of things around the table. You can refer to this. She is the third justice since 2000 to die in office, ruling Rehnquist in 2005 and Antonin Scalia in 2016. The process, obviously, as you've seen, is expected to be controversial, in part as a result of the acrimonious process of replacing Justice Scalia, which was delayed by the Senate Republicans that held the majority back in 2016, that would not consider the Obama administration until after the election. In history, there have been open Supreme Court vacancies in a presidential election year 29 times. I didn't know this. I thought it'd be fun to put in. And well, it's fun lawyer stuff. I'm not sure if it's fun for anyone else. And the president made a nomination in all 29 cases. Here's what happened. 19 times between 1796 and 1968, presidents sought to fill Supreme Court vacancies in an election year while their party controlled the Senate. 10 of those nominations came before the election, and 9 of those 10 were successful. The rest came after the election, and they were successful too. But I thought before the election was the data point for us. By contrast, when the president and the Senate were from opposing parties, and there had been 10 vacancies resulting in election year or post-election. So in the year or after the election occurred. In 6 of those cases, the president made the election before election day. Only one of those judges was confirmed by the party that controlled Congress, which again was the controlling party. If you happen to be playing Trivial Pursuit and this somehow is a question, I don't see how, but that president was Grover Cleveland, and that was Melville W. Fuller, who was the justice who was appointed in the court. I don't even know that I will remember that, but I guess I always go back to my slide. So, why does this matter? Why are we all even having this discussion? So it basically falls down to this, and it kind of goes back to all of the other slides that we just went through, which is why I think I made it the last slide in the federal section that we covered. Because everything that you see happening in Congress finds its way somehow, potentially, to the Supreme Court to determine whether or not it's constitutional or not. I know the discussion that you're seeing on TV and potentially radio and on the internet. I'm glad I mentioned the internet so it didn't make me sound so old. But anytime you see this discussion occurring right now, you're hearing things about Roe v. Wade and it's overturning Roe v. Wade. And I hear it, I understand it. But for our purposes, it matters for a different reason. Right? All of the things we just talked about, the FDCPA, the CFPB, the FTC, and even state laws concerning these issues find their way somehow to the Supreme Court at some point to determine whether or not they're constitutional, whether or not they should be the law. Just like the CFPB just found its way to the Supreme Court, it will again. A Congress controlled by one party and a president of that party will make laws that people won't like. And a lot of people will. But you will see those laws challenged, just like we saw the ACA challenged back during the Obama administration. So you will see things like that happen. And what the court looks like, how it is constituted, will matter a great deal on whether these laws continue to be constitutional or not, whether these laws remain in effect or not. Right now, the court has a conservative slant of 5-4. Were a Trump nominee to be nominated and that confirmation occurred, then you would see a 6-3 conservative court. And in that situation, you might see some of these things that the House or the Senate or the president or all three together of the same party are looking to make law be challenged in the Supreme Court, and the Supreme Court might be the last arbiter of those decisions and on those laws. For us, I think that's why it matters, not some of the things that you're hearing on TV. These aren't the as I call it, the sexy discussions, they're business discussions, but it really will matter, and it'll matter to a lot of people, especially us in the credit union world. So let me go through this. So the last 2 sections are East Coast, West Coast sections. I won't spend a lot of time on them. Again, I wanted to spend most of my time on federal action and federal courts because I think that's what really matters most to us. But let's just go through it real quick. So you've seen, if you've been to any of webinars or even to the lending conference, you'll see some of these slides, but I just want to go and let people know where these things are. So here are some of the highlights from the various state actions and then the various court actions. So in Maryland, no repossessions or foreclosure until the state of emergency has been lifted, last renewed on September 8th. That has pushed back. You should have the expectation that's going to push back until after the first of the year. So we will see no foreclosures and no repossessions in Maryland probably until 2021. Certain jurisdictions have begun sending letters to defendants in collection matters suggesting they attend counsel. This is a new thing that we're seeing in the state of Maryland. Judges are sending letters from their chambers to defendants saying, hey, maybe you should think about getting a lawyer. Maybe you should maybe you should talk to that lawyer about settling. Maybe you and your lawyer should reach out to the plaintiff to talk about settling. If not, just put a notice of intent to defend in so that we can hear your case. I've never seen this before. The court said this was they said that the reason they were doing this was to try to encourage settlement. It seems like they're just encouraging people to lawyer up. I'm not really sure why, and it doesn't seem to make a lot of sense, but it's what's going on. Maryland courts are limiting hearings in Montgomery County for right now, but almost every other county is doing the same. Towards Zoom. There was a new Zoom. One of my clients asked me about this yesterday, called Zoom for Government or Government Zoom. I don't think they've really named it yet. But this is a secure platform that allows people into the Zoom room, but only if they're scheduled for that day and get a specific link to come in. These are public hearings. If you went to court and there were 50 other people there, it would be a public hearing. These are no different. They're not private. They're not proprietary. If you went in with 3 other people from your credit union, it would be fine. Witnesses are being sworn in these Zoom rooms, and evidence is being heard. So just bear in mind, you may start to see some of these hearings in the state of Maryland. District of Columbia, I could read through this, but I'll just say the same thing. There are no collections permitted in the District of Columbia. They are taking cases in the court, but have pretty much said that they're not doing anything with those cases. And I haven't even seen a summons issued by the District of Columbia. I don't remember when. Could have been before the pandemic, or maybe just slightly after. In any event, collection activities are prohibited for 60 days after the emergency. It currently expires in December, but again, you should expect that to extend into 2021. It does not apply to original creditors. Clients have asked us about this. You can still collect on your debt. We cannot, but you can. DC has also banned repossessions and garnishments through at least December 8th. Now, the important part of that is they have not banned mortgage actions or foreclosures. I'm not sure of why, but repossessions and garnishments are banned. In Maryland, as I said, all of those are banned, but not foreclosure in DC. So on court action, moving away from state action, Maryland has begun a phased reopen, currently in phase 4. Through October, non-jury trials have been resumed. Again, many of them will be Zoom. Phase 5 should begin in October with full open courts and everyone being in court. I sincerely doubt that will happen. But right now it's scheduled, so just bear in mind, you may be sending witnesses to court. Some Maryland courts actually are hearing cases with witnesses. Not many, but a few. In DC, despite the moratorium, as I said earlier, the courts are open with social distancing guidelines. What I can tell you about, and let me just go through Virginia on court actions. The courts are open. Reopening decision guidelines were made at a county level. Limits on the number of cases heard in a day, and limits on the number of individuals allowed in a court. What that basically means is that Virginia has decided that COVID passed over them. So they're pretty much running as if they were always running, although in the defense of Virginia, they are limiting the amount of people in the courtroom, limiting the number of cases that will be heard in a day, and limiting the number of actions. So they are not having a courtroom full of people, but they are having courtrooms with people. Something that you're just starting to see in the other area jurisdictions. For a more comprehensive list, you can take a look at the really long Google link, and it will pretty much tell you everything in 100 or 200 pages. Let's see. Oh, I wanted to bring up one other matter, and I know that I'm rushing through this, but the courts are taking great and really going to great lengths to make sure people are safe in court. If you are going to court, if your lawyer says, hey, you got to go to court, I would say fear not. They really are doing a great job of keeping people away from each other, keeping the courtrooms with small groups and keeping those groups away from each other. So I wouldn't worry so much about going to court if you have to. I also threw in Pennsylvania and North Carolina because those are areas where we practice. Again, in the courts in those jurisdictions, Pennsylvania has been open. They've been hearing cases with social distancing. North Carolina has been open since June. No jury trials till October because they don't want people sitting so close to each other. This is, by the way, in almost every jurisdiction. The reason why we put North Carolina in here for October 1st is they've actually given a date. No other jurisdiction has provided a date for jury trials, but I would expect that will push back. Many hearings can be conducted by teleconference. All of our North Carolina hearings, by the way, are teleconference. Documents can be notarized and submitted. Other documents can be served by mail. Filings submitted by mail will be timely received 5 days before the due date. Clerks require appointments and limit the number of hours public records are available. So we threw North Carolina and Pennsylvania in here for those purposes. We also threw in Florida where we practice. Florida is, if you look at the map, we thought we'd throw in a cool map. If you look at the map here, what you'll see is the phases that the various counties are in, because this is county by county in Florida. And what you'll see is that everyone is in phase 1 or phase 2. There is no phase 3 or phase 4 in Florida. And pretty much that's all I'll say about Florida. So the overall effect, what you'll see here is on current cases, Maryland's rescheduling trials and many matters are being rescheduled for the spring. Virginia are putting strict limits on their courts, but they are having cases heard every day. DC, no civil action filings. Small claims hearings have been canceled. Large civil actions that are already filed are proceeding remotely. In Pennsylvania, courts are accepting new cases and have dockets. North Carolina have had cases continued for months, but still hearing. And the courts have tough restrictions in Florida, but they're conducting almost all of their hearings remotely now. So they are having hearings, but there's been significant interruption. So let me just wrap up the East Coast here. By the way, if you saw, I discussed state action in a few states, but not others. The reason why is that in Virginia and Pennsylvania, North Carolina, and Florida, there's really no state action to report that would affect credit unions. It's really the court actions that affect credit unions. So on court actions, you should see a delay in processing new lawsuits, a delay in scheduling trials, a delay in the timelines to obtain judgments. And in DC, depending on when the collection actions will be permitted, the backlogs will exceed at least 1 year. Here's what I would tell all of you. If you have collection actions, I would get them to lawyers in collection cases. I would get them to lawyers as fast as possible to work towards settlement if possible, only because anything that we file now will probably be heard mid to late to maybe after 2021. The courts are backlogged. They're barely filing these cases. They're barely issuing summons. This is in every single jurisdiction. Some are better than others. I'm going to go to the West Coast now. We have 2 states we're covering, California and Washington. So what you'll see here is the state action in the state of California dealing with the pandemic. And what I would suggest to you is this is state action that will continue into 2021. I won't go through all of it, but I will say that California has declared a state of emergency to contain the coronavirus. And they basically stopped almost all, well, what I would equate it to, California has taken the action that the federal government took under the CARES Act. And so you're seeing in California very little collections. You're seeing very little, actually no actions on evictions or anything relating to evictions. No actions on foreclosures. And we'll talk about it in a second, but they are hearing cases. What you'll see here is a few of the assembly bills and, again, county actions and city actions taken. The first 2 are COVID-related for landlords and tenants, and the last is action taken in San Francisco and Los Angeles. Again, it's the same thing that we talked about with the CARES Act, and the same thing that I just talked about a moment ago, which is debt collection is pretty much at a halt in California. Actions on real estate are at a halt in California. Pretty much the only thing that we're seeing out of California is cases that have already been filed in California are being heard, but only being heard remotely. And I think we have a slide on that next. Washington State, same thing except for lawyers, same thing except worse. There was a proclamation on April 14th to regulate debt collection activities. State of emergency was issued with a current extension to October of 2020. You should absolutely expect, if you work in the state of Washington, or have cases there, that October 1 date to just be extended. Enforcement by their AG, you're seeing a lot of enforcement by the AG on matters relating to residential real estate. And notwithstanding the moratorium on evictions, notwithstanding the moratorium on foreclosures, some folks are still trying to go through, and you'll see penalties that were recently awarded on robocalls, which is a violation of their new Consumer Protection Act. In court actions, in California, as I just said, they're staying decentralized. It's really county by county basis, but if you work in California, what you'll see is the counties are making the decisions, but those decisions are to hear the cases that have already been filed electronically. It's easy to go through Washington. They're just not doing anything. The courts are basically closed in the state of Washington. We really don't have an idea of when they'll be opening. They're trying to issue guidelines now on when they'll be opening or how they'll be opening, but no one really knows. Overall effect, California has its own CARES Act. We talked about that. We should have the expectation that that will continue well into 2021. There's no sign of that changing. In Washington, garnishments, previously suspended consumer debt, currently not applied to bank accounts and other CARES Act stimulus. Basically, in California and in Washington, there's an exemption as to stimulus funds for bank account garnishments and attachments. And I don't know how you determine that, but it's your job to determine that. We've not seen that on the East Coast, only on the West Coast. In bankruptcy, move forward a slide. In bankruptcy, what you'll see is some hearings are being held, but again, those hearings are being held electronically. You'll see no in-person hearings being held on any matter until further notice, but they are hearing matters electronically. They're mostly emergency hearings, but they are being heard. In Washington, you're seeing the same thing. The courthouses are closed. Most bankruptcy courthouses, by the way, are closed across the country. Everything is being done electronically. Filings are by appointment or electronically. They've moved to electronic filings faster than most other courts. Foreclosures, again, you're seeing foreclosures basically at an end. There's been a moratorium on evictions. It's the same thing I've said and said over again. Repossessions, there's no moratorium on those in California or Washington. So if you've gotten to the point where you can get take a repossession, feel free to. What do we learn from all of this? What do we get out of all of this? Hopefully something, and I didn't waste everyone's time. It's 11 o'clock, so I'm going to take just 2 more seconds. What I've told all of our clients, and I've used this slide before, it's time to rethink how you're approaching collections. Obviously, we can't do a lot right now, but the things we can do, we're doing. We are filing lawsuits where we can. We are taking judgments where we can. We're certainly working the phones with our letters and our phone calls, but it's limited. And what we'll be able to file is limited, and when we'll be heard in court is limited. So what I tell clients is it's time to think beyond what they've been doing, maybe create new policies to deal with hardships. And we've seen all of that with all of our clients. I put these next 2 facts in here because I think they're important. First, we've had clients who've stopped collections. And what I would say is that, the unemployment rate in the worst place in the country is at 15%. In the Mid-Atlantic, it's currently less than that 7.5% that I have there. People are working, people are getting paid, and they got those stimulus funds where I've put into other webinars that people are spending more than 50% on those funds to pay down debt. Take advantage of that if you can. And then it's important to look at the optics on how you refer accounts, file suit, and attend court hearings and take judgments. If you let things just sit, if you say, I'm going to take a step back and not do anything, which we've had clients do, just know at some point in time, you'll have to turn that spigot back on. And when you do, you'll be filing 2,000 lawsuits or 200 lawsuits. I don't know how great that looks. You need to start thinking about post-election and post-pandemic collections. If we see a HEROS Act come down the pike or something like it, collections get shut off. The opportunity is now, if you're going to do anything, because in 3-4 months from now, 5 months from now, you may see collections come to an end. And then again, prepare for the coming wave. If the market goes down based on the election, if consumers lose confidence because of the election, you'll see your bad debt portfolio get a lot higher. And when that portfolio gets a lot higher, then you need to start thinking about how you're going to deal with bad debt. Is it bring new people in as customer service reps to try and deal with that, or send that out to collections? I know that I went a minute or two over. I apologize for that. I want to thank you all for your time. I really appreciate the opportunity to speak to this group. I always love seeing you in person, and I hope someday soon I will again. Thanks very much.